Yeah, hi. Now we are going to see that important judgment in which the Supreme Court had revived the dead laws. The name of that very famous case is Bhikaji Narain versus State of Madhya Bharat or State of Madhya Pradesh of 1955. Let's rewind to the early years of our republic, the 1950s. India was newly independent. Its constitution was very fresh and it was glowing like a newborn sun. Now the thing is that in this particular scenario in 1947, Madhya Pradesh, means erstwhile Central Province and Barar, it passed an act known as CP and Barar Motor Vehicle Amendment Act 1947. It allowed the government to nationalize the private transportations, basically taking over the private bus services. Among those affected were Bhikaji Narain, dhakras, who was the owner of the private transportation, and other private bus operators. You might have seen in MP large number of private bus operators. Bhikaji Narain Dhakras said, "You can't take our buses, you can't take our routes right away. It violates our right to trade and property enshrined under fundamental right." Now, when the Constitution came into force on 26th of November 1949 and fully on 26th of January 1950, Article 19 subclause 1 subclause G enshrined the Constitution ensured guaranteed the right to practice any profession or trade. And Article 13 said any existing law inconsistent with the fundamental rights shall be void. So, making an analogy with this particular two articles, Article 19 subclause 1 subclause G and Article 13, Bhikaji Narain Dhakras said that this CP and Barar Motor Vehicle Amendment Act of 1947 is inconsistent with our fundamental right, and this act of CP and Barar has got dead because of the fundamental right given by the Constitution. But thereafter the twist came. The Parliament passed the first Constitutional Amendment Act in 1951, adding Article 19 subclause 6, which allowed the state to create monopolies in trade and business. Now the law which was feeling unconstitutional in the initial instance after the first constitutional amendment, it again start feeling perfectly valid. So the big question which came before the Supreme Court, can a law that became void after 1951 can come back to life again after a constitutional amendment act? In this particular judgment, the Supreme Court said a pre-constitutional law inconsistent with the fundamental right is not dead. It is only overshadowed by the Constitution like sun eclipsed by the moon. It may revive, it may rise again if it is focusing on implementing constitutional morality. And there gives the genesis of doctrine of eclipse, which in future have been followed in large number of judicial pronouncements. Thank you.